Can a WhatsApp message win a case in court? Can CCTV footage alone prove guilt? The Bharatiya Sakshya Adhiniyam 2023 has completely transformed India's evidence law, and today, advocate Mukund Mahajan will explain the most important changes you must know. Friends, the Bharatiya Sakshya Adhiniyam 2023 is a landmark reform in India's legal system. It recognizes digital reality, strengthens investigation, protects individual rights, and promotes speedy and fair trials. Understanding this law is essential for every legal professional and informed citizen.
Welcome to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. I have a humble request. You can scan the GPay QR code shown here and contribute a small amount of 59 rupees or 119 rupees as per your wish through any UPI app to get membership of this channel. You may cancel the membership anytime. Your small support will further strengthen my efforts to spread legal awareness among citizens and provide correct legal information to the common people. Now, let's move ahead. Definition of evidence expanded. Under the Bharatiya Sakshya Adhiniyam, the definition of evidence has been expanded and clarified. Evidence now includes oral evidence, documentary evidence, and electronic and digital evidence. Sections 2 and 3 define evidence and expressly include electronic records. This means emails, WhatsApp messages, SMS, call recordings, CCTV footage, computer-generated documents, cloud-based data, and digital signatures can all be treated as evidence. This is one of the most revolutionary changes, recognizing that today's crimes and disputes are largely digital in nature. Electronic evidence equal status. Electronic evidence has now been given equal status. Earlier, under the Indian Evidence Act, 1872, electronic evidence was often rejected on technical grounds. However, under Sections 61 to 63 of the Bharatiya Sakshya Adhiniyam, electronic records are treated at par with paper documents. The output of electronic devices is admissible, and courts can rely on servers, mobile phones, laptops, cloud storage, and automated systems. The law now ensures that justice is not defeated due to procedural technicalities. Oral evidence direct but modern. Oral evidence continues to remain direct but has been modernized. Section 55 states that oral evidence must be direct, meaning a person must depose what he has personally seen, heard, or perceived. A significant new feature is that oral evidence may now be recorded through video conferencing and electronic means. This is extremely useful for witness protection, cases involving senior citizens, outstation witnesses, and for ensuring speedy trials. Documentary evidence expanded scope. Documentary evidence has also been expanded. Sections 59 to 64 clarify that documents include paper documents, electronic records, digital data, and computer outputs. The Act continues to recognize primary and secondary evidence. Primary evidence refers to the original document or original electronic record, while secondary evidence includes copies, printouts, certified copies, and digital outputs. This makes the Act technology neutral and future-ready. Presumptions regarding electronic records. The Act also introduces presumptions regarding electronic records. Courts may presume the authenticity of electronic messages, validity of digital signatures, and integrity of secure electronic records. This shifts the unnecessary burden away from genuine litigants and simplifies the process of proving digital evidence. Confession and statements safeguards retained. Confession and statements retain constitutional safeguards. Confession made to police remains inadmissible. Confession must be voluntary, and confession made in police custody is admissible only if recorded by a magistrate. Electronic recording of confessions and statements is now recognized, ensuring transparency and accountability in criminal investigations. Expert evidence broader recognition. Expert evidence has been given broader recognition. Experts may now include cyber forensic experts, digital data analysts, medical experts, handwriting and fingerprint experts, and ballistics experts. This is particularly important for cyber crimes, economic offenses, fraud cases, and technology-based crimes where technical expertise is essential. Burden of proof clarified. The burden of proof provisions have been clearly explained. The burden lies on the party who asserts a fact. Facts, especially within the knowledge of a person, must be proved by that person. Possession may create a presumption of ownership. These provisions help courts apply logical reasoning in deciding cases. Relevancy of facts simplified. The relevancy of facts has been simplified. The Act explains what facts are relevant, facts forming part of the same transaction, and facts explaining or introducing relevant facts. It also clarifies motive, preparation, and conduct. Circumstantial evidence principles remain intact but are now clearly worded. Character evidence. The Act also explains character evidence. It clarifies when character evidence is relevant, when it is irrelevant, and the difference between civil and criminal cases. This prevents misuse of character assassination during trials. Removal of colonial provisions. Another important reform is the removal of colonial and obsolete provisions. British-era terminology, outdated illustrations, and colonial references have been removed. The language is now Indian, practical, and contemporary. Alignment with new criminal laws. The Bharatiya Sakshya Adhiniyam is fully aligned with Bharatiya Nyaya Sanhita, 2023. Bharatiya Nagrik Suraksha Sanhita, 2023. This ensures uniform interpretation, faster justice delivery, and reduced contradictions in criminal trials. Conclusion. Friends, the Bharatiya Sakshya Adhiniyam 2023 is a landmark reform in India's legal system. It recognizes digital reality, strengthens investigation, protects individual rights, and promotes speedy and fair trials. Understanding this law is essential for every legal professional and informed citizen. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.